who's going to be on the phone and on the call as well. And so this is a good example. We are in the process of we have identified a number of groups around the country that specialize in working with African women. And so we can take a look and see who we know, and I can have Corinne look into that. And as we go through this presentation today, Rocio and I may make a note to Corinne that we will augment the resources we prepared for this training with issues and information that we identified during the process of delivering the training that match and supplement the information that we've provided that can help you in this kind of an example as well. And I will just say that many of the agencies that focus on immigrants or refugees, and Jewish social services can be a good example, don't limit their services to only one population. So you don't have to think the African has to go to the African program and the Jewish person has to go to, they can all go to other, when they're working with refugees, they work with refugees from all over. Rocio.
Welcome, everybody.
Please, who's ever controlling them.
Yeah, we'll go. First, it was a thank you for having us here. I'll tell you my background. I worked at the Wisconsin Coalition Against Domestic Violence before doing national TA with Leslie. And there I represented immigrants and immigration cases, and I worked side by side with the family law lawyers. So a lot of the issues that you might be in, I've seen them firsthand on the ground and can support you in any way I can. First, a thank you to OVW. They fund our projects. We're a technical assistance provider. So that really means that we can provide you with resources, information, connections, anything. There's really nothing that we won't do to help you here. And so do reach out to us, because that is our job, to support you, and I thank you for your hard work. I'm going to give you a moment, Leslie, to tell us a little bit about your expertise.
Sure. So I guess we could start. So I am a family lawyer. I started my career back in the 80s representing immigrant survivors exclusively. Before there was any form of immigration relief, I actually was doing work even before there was a battered spouse waiver in 1990, and was involved. And so because I was running a direct service, so I did direct services, legal, and I guess you could say social work and victim advocacy services for immigrant survivors, because the program I ran really for many years was the only game in town. And so even though we were lawyers, we did help people get benefits, help people find shelter, food, all the same kind, healthcare, all the same kind of things that victim advocates do. And so I thoroughly enjoy working with victim advocates. The other part of my personal history is I happen to be in the right place at the right time in the early 90s, and had the privilege of being involved as the essentially lead lobbyist on the drafting of the VAWA self-petition, the U visa, the T visa, parts of special immigrant juvenile status, battered spouse waiver, benefits access for immigrant victims, legal services access, et cetera, and done a lot of work. Our whole program has done a lot of work, Rocio and I in particular, working with the Department of Homeland Security to make these laws work. So we've also worked on regulations and policies, et cetera. So we can answer a lot of questions and really want to be, the way we think about it, next slide, please, is that we, as Rocio said, are here to support you. Those laws and regulations and whatever else we may have gained legally are just pieces of paper if, without the work that you guys are doing in the field with victims and being able to use those laws to help them. And the assistance we provide is so that, like when I started doing my work, there was nobody to call to ask, how do you do X? Because we were like inventing it. And we don't want you to have to do the same, because if we can support you, then the numbers of victims that you can help are exponentially increased if you don't have to figure everything out. And so part of what we try to do is create a toolkit, information where you can go read and use checklists and things like that, that help victims access benefits, access court, get interpreters, file for immigration relief, et cetera, et cetera. And And so that's what we do. We provide these kinds of trainings and technical assistance and materials. And you can ask us, as Rocio said, anything. If you ask us something and we've never done research on that, then one of our students like Corinne or others will get assigned to do that work and we'll deliver it to you. And that's why we like doing this, so that we can support you, and we always get new interesting questions and things to research. Next slide, please. So we provide technical assistance not only to victim advocates, but to judges, police, prosecutors, sheriffs, other professionals. We have a team of police officers, prosecutors, and judges who provide direct technical assistance to their own professions. So if you are working with a law enforcement officer and they want to learn more, but they want to they're willing to talk to another law enforcement officer, we can make that happen for you. Same thing with a judge, same thing with a prosecutor. Next slide, please.
We covered that.
Do I keep going or you take over that?
Well, I think this is the type of directory assistance, and these slides, we'll share them with you after so you guys can have them for reference, but I'll go ahead and take the one after that, this one.
Okay.
So these are the questions that we have beforehand, but if something else that, is related to this that you want answered, feel free, let's interact, let's answer them, because we can answer these for you in a Q&A after and share it with everyone as well. Yeah. Go ahead, Liz. Or you want to ask Leslie and then she'll answer?
I'll tell you, you ask me the questions, I'll answer them, and when it's your turn, I'll read the question and you answer.
Okay, so you have cannot read.
Put you on the spot.
Long been involved in advocating for VAWA. Can you give us a brief history of how the VAWA self-petition, U visa, and T visa came to be?
Sure. So these are pieces of legislation that have always been bipartisan. Next slide, please. Both sides of the aisle, we had bipartisan support in the House and the Senate, and the purposes of all these different kinds of immigration relief come down to a combination of things: victim safety, improving the ability, and if you actually look at the legislative history of the U visa, you'll see that Congress wanted police and prosecutors departments to do a better job of reaching immigrant victims. And it actually says that in the legislation, to improve their work with immigrant victims, improve everybody's ability to fight crime, hold the perpetrators accountable, and keep communities safe. And so it was all of those different reasons that the Violence Against Women Act immigration provisions were created. Next slide, please. And then when you look at all these forms of relief together, this, for those of you that recognize the U visa, this looks a lot like the U visa list, but it has actually got more than that. It is all the forms of immigration relief together. So the VAWA self-petition was the first two forms of relief historically were the VAWA self-petition and the battered spouse waiver. Both of those were made, oh my goodness, my husband didn't take the phone out of the room, I'm sorry. But he did answer it. Yeah, both of those forms of relief were designed for people whose abusers were their US citizen or lawful permanent resident, spouse, former spouse, parent, step-parent, or adult over 21-year-old US citizen child. So that was the first group of people, and that was a group of people that theoretically had visas waiting for them if the perpetrator filed. And some of you will see cases where the perpetrator actually filed the immigration case, but that was the VAWA self-petitioning, and that was created in 94 and augmented in 96. And the VAWA self-petition, and then there are protections from deportation that go along with that. The second form of relief, but what we realized was that sexual assault survivors, stalking survivors, human trafficking survivors, victims of child sexual assault, other kinds of victims were left out of the original VAWA self-petition protections. And so the U visa and T visa were created for those groups. And I will also mention here that special immigrant juvenile status was also created in the early 90s and improved in 2000 through VAWA 2005 and the trafficking bill of 2008. And many of the children, at any of the time you're working in a case where you have an adult, parent and a child both abused by the child's other parent. So, it could be a marriage, could not be a marriage, doesn't matter. The child who's abused by their parent or step-parent could also qualify for special immigrant juvenile status. And that's really important because the wait lists on the adjudication process, a child can get an approved special immigrant juvenile status case within 1 to 3 years versus the much longer wait for U visas. So these all work together as forms of relief for victims, and were created that way, and were created for that purpose. Next slide, please.
Can you provide us a policy update of issues impacting immigrant survivors of violence at a federal level?
Sure. Next slide, please. So what we're seeing, kind of emerging issues that I think are important for people to be aware of, it continues to be very, very important. And this is why the role of advocates is so important, and identifying cases early. For victims to file a good, strong, well-documented case as soon as possible. And sometimes that becomes like, if the legal services agency has a long waiting list, it might be because what happens is until victims file, the Department of Homeland Security doesn't know their victims. And if the perpetrator calls to try to turn them in, they will react. And so the only way to stop them from reacting is to have a case on file. It's not quite that simple, but we provide lots of technical assistance around it. So filing early is still important, but filing a strong case, because in this day and age, if you file a case, let's say you forget to include the cert, or let's say that you haven't effectively proved in the case that the abuse, that the victimization caused substantial harm to the client. If you file a weak case, it used to be that they would give you a request for further evidence and you'd have an opportunity to supplement the record. Now they're denying those cases sometimes immediately and turning people in for deportation. So
with that, I was going to say, if you get a snag in the case, don't wait for it to fix itself or to try to do some advocacy through paperwork. One of the biggest mistakes that we see is that as soon as the mistake was flagged, they didn't contact us or someone else that has a liaison with the Department of Homeland Security, so that we can help you fix it with supervisors and something. And there's other stuff that can be done. And sometimes we know we're in the right here, so we know that we think it'll sort itself out because we filed the cert, or it's a strong case, or in the past they would sort themselves out. But now don't be shy about contacting your partners like us and Assista and ILRC and others to do administrative help in the back end.
Right. And partly that's because what happens is if it gets too far along in the process, the people with the power to fix it easily lose the power to fix it easily. And the more people, like if you wait and try to go a straight litigation strategy, you can cut off options that were available early on to fix the problem. So do call us if you run into a problem early on. We've been very able to get people to do the right thing when it's their mistake, and there's lots of those happening. Blank spaces. It's really important if you're working on a case that the lawyers or if you're helping a victim working on a case, making sure that the forms all say not applicable, because they've changed the policy and they're rejecting potentially both certs and applications that have blank spaces. The other emerging issue is there's lots of information and confusion about public charge. I'll just make this very simple. Public charge victims are exempt. Basically, anybody filing for VAWA, T, U, SIJ, DACA, all of those people, public charge, they're exempt by law. So it's not a problem. Getting public benefits is not going to harm a victim. And then there are new filing locations. And so you'll see it further on in the slides. We have some tools we've developed for you that Corinne actually worked on, and we want to thank her, that we will distribute to you after, that he'll show you where you file based on where you live, because some of the cases, half of the country goes to Nebraska, half of the country goes to Vermont right now. Next slide, please.
Leslie, there was a move forward in judicial certification where now the adjudicators and that are reviewing the cases, it's very clear that a protection order or a judge signing a certification can be the basis of the U visa, which we always knew it was, but that's ironed out among them. And
right. And they've actually trained all of the supervisors in Vermont and Nebraska within the last month on this issue particularly. So yeah, so judicial certification is, you guys are in one of the best states to do it because your judges have all been trained on it. And there's a team of judges available to help. So that's a great thing. So the next question, Rocio, what are you hearing about,
about COVID and challenges?
What are you hearing about how immigrant survivors are being impacted by COVID, and how can service providers best respond?
What we're hearing, and if you can go to the next slide, there was a lot of confusion about who was eligible for the money back or eligible for the CARES Act. And so if they didn't have a social security number, or one of the, let's say the one party did, but the other didn't, they were denied that benefit. From farm workers in California, we're hearing a lot of people getting laid off because of not being able to work, or if they're working, then they have to expose themselves to be there without a lot of protection. What are you guys seeing in Missouri, if somebody wants to share?
COVID relief, or I'm sorry.
What are the challenges that you see immigrant victims having in, other than not being able to access, or confusion whether they can get the access to the CARES Act, unemployment, safety concerns?
I haven't had a lot of any experience with them with accessing CARES. I haven't run into that yet. I feel like what I've run into with the clients that I've worked with is they're leery to share very much because they still have a lot of I don't know, the ones that are here with their families. It just seems like it's kind of hard to get them to open up very much.
Yeah.
So I feel like I haven't been able to get very far. Like any client that I've worked with any organization, it's almost like a 1 or 2 day and they're gone. And so that's why I was hoping, I found another organization, I don't know if anyone's worked with it, but I guess I need to dig in with these two organizations, Refugee Casey and Rise, to see what information I can get to them quickly, because they don't seem to be very long-term in my experience.
Mm-hmm. So
as far as staying connected with our agency or our series. That's only been my personal experience. I don't know, CJ, have you?
We've had some immigrant clients who have stayed in our program, in our shelter program, and later in our transition living program for over a year.
Okay.
And part of it was because getting their visas and going through all this legal stuff, and they were severely in danger from their abuser.
So I saw something too, it said that we get 500 immigrants or refugees settled per year in KC. Does that number sound right? And it said we were getting a lot of them from Somalia, Burma, Sudan, Syria, and the Democratic Republic of the Congo.
So what's really interesting, I think what's important, particularly when you're talking, so there's two kind of things going on. One, as to refugees, what's important to know is I really do think anything you guys can do to build relationships with the programs responsible for resettling refugees is really important, because the way those programs operate is they provide services, generally speaking, to the head of household, who is often the abuser, and who may be the abuser. And they don't have a lot of information. The refugee resettlement agencies writ large don't have a lot of information about working with survivors, which is why setting up a partnership so that maybe they're handling the refugee part and you guys are handling the victim services part, and that you can intercede to help them advocate correctly so that, you know, victims don't get stuck, because that's one of the things we see nationally with refugee resettlement organizations. As to COVID, if you could go to the next slide, one of the things, I think one of the main points we want to make is it is true. Anytime you work with an immigrant survivor, now or even before COVID, part of our job is to give people information and let them know that your door is open, and that, you know, that client who's there for 2 days gets the information and then, you know, doesn't come back. You'd be surprised. I mean, that's how it was with me back in the 80s as well. And what we found was that over time, people do come back, so that you don't know whether you're being effective in communicating until a year later she shows up or her sister shows up on your doorstep. And so you just need to kind of measure your success differently, I think, and that you want to know who to connect them with, but really make the point that whatever, see, because with immigrant survivors, because of this immigration process and how long it takes, we've done social science research over this, and again, what we find is that we need to figure out a way to provide the advocacy to victims while they're living with their perpetrators, because immigrant victims generally, many, like 40, 60, 50%, lots of them, don't even try to leave until they get work authorization. So that can take from 4 months to 6 years, depending on the kind of immigration case they qualify for. So our job is to figure out how to make sure they know they can safely contact us and we can support them despite the fact that they're not separating today. So things like, I've gotten hundreds over my career of protection orders, more than hundreds, protection orders on behalf of immigrant victims who are currently living with their abuser and don't expect to separate. And those can be very effective in reducing the violence and empowering her and helping her, and safety planning is just huge in these cases. So as to the COVID, I just want to say, if you go to our resources on it, you can look up, because the biggest problem we're seeing with victim advocacy and attorneys around this is many of you might be, raise your hand if you, let's see if this works with the people on pictures. If you've worked with somebody who had a green card, who was a lawful permanent resident. See some hands? Yeah, exactly. So how many of you worked with a victim who didn't have lawful permanent residency, but had work authorization? Yep, a lot of hands there. Any immigrant victim who has legal work authorization can qualify for the CARES Act payments if they pay taxes. And you can pay taxes late. Well, we're coming up on an October deadline, so I don't know how all that works. But the point is, they qualify for care and they qualify for unemployment. And so the protections, and then there's lots of housing protections and healthcare protections that apply to everybody without regard to immigration status. So we have that information. We have available for you in these materials that you can use. We should probably go to the next slide.
Great. That's great, Leslie. Thank you for making that point. Moving on to the VAWA self-petitions, wanted to share with you that we have an extensive VAWA self-petition webinar. Here's the link for it. But there we cover process, eligibility, and ways that advocates can support survivors applying for a VAWA.
There's materials and checklists and everything else there too for you.
Can you go to the next one?
So Rocio, how would you describe the advocate, service provider, non-attorney's role supporting a survivor through the process?
Right. So I've worked really closely with advocates that support, we're supporting survivors apply for VAWA self-petitions. When I worked at the coalition, I used to have a long wait list in order to be able to serve everyone in the community that needed help. And so by gathering the well, first of all, you're the people come in through the door, and as an advocate, you have a unique opportunity to be able to screen and let them know that this remedy exists. If you're not sure, reach out to somebody, reach out to us. We can look at the facts with you a little closer. And then letting them know this remedy exists. Maybe they're not ready to leave their abuser. None of the immigration remedies require you to leave the abuser. So it's good to let them know that there's this option. You don't need to leave them. It's confidential. This is the list of documents that you're going to need. And they can start thinking, maybe they're not ready to do it now, but they can start to gather those documents, make copies of the things they might need. And when time comes to it, they can apply for that. I've seen advocates support by writing affidavits in support of the immigration case. So based on your expertise in working with women and survivors, you can say based on what she told you, you see how it's impacted her. You can say that she's gone to your agency for services. All that all just strengthen her case. I've seen advocates help with translation, language access with the attorneys. So there's a lot of opportunities, and I think we as attorneys, we can serve more people in a better, more holistic way, and definitely in a trauma more informed way if we're working together with advocates.
Next slide, please. Did you get all the, oops, you got that.
Yeah, I think, oh yeah, so you know, screening, identifying the documents, the declaration. We have a great tool on how you can work to do a declaration in a trauma-informed manner. The relationships that we build with law enforcement are essential in getting U visa certifications. Sometimes the client will be more likely to disclose to an advocate something in her criminal history or immigration history. So you are key in sometimes identifying these red flags for us and then collecting other evidence. Next slide, please.
So what are the first steps a survivor should focus on for a VAWA self-petition?
When I'm screening to see if somebody's eligible for a VAWA self-petition, the first thing I ask is who is the person that, who's the abuser. It's battery or extreme cruelty. So I keep in mind that it doesn't have to be physical, or there doesn't have to be a criminal case. And if it's their husband or partner or boyfriend, I ask if they're married. If they're not legally married, then they can't apply for a VAWA self-petition. So that's one of the first steps I focus to see if they're eligible. So it's if they're legally married to the person, and if that abuser has immigration status. It could also be their parent, but again, the parent would have to be a U.S. citizen or lawful permanent resident, or it could be their child that's over 21 that's abusing them. But I'm looking for the relationship that exists. And I'm next looking to see if the abuser has immigration status. You want to add to that, Leslie?
No, I think that's great. And don't forget about step parents and people who get divorced. You have within 2 years of divorce to file.
Great.
What are the key elements that a survivor should include in their affidavit or their statement, and what advice do you give people on writing the statement?
Yeah, I think I think always remember a survivor's ability to write a statement. There's very often that they do not have the ability to kind of write or put something together, but there is, if they have that capacity to do so, there are a lot of advantages for them writing it down. They say it can be healing, but if not, that's our job to support them through the process. One of the key elements I see is a lot of people tend to focus on the relationship with the perpetrator or the abuser. So they'll write about the things that they've done, maybe cheating, other things that are important to us in a relationship. But especially in the U visa, the focus is the crime, how it impacted you. And I mean, the crime, how you were helpful, and how it impacted you. So I think one of the things that in writing the statement is, be working at the survivor's pace, know that it may take a number of days and months. very often when I start working at the declaration, that's when clients kind of fall off the map, and it's harder to pull them in there because it is really hard work for both of you to do it. So patience, and sometimes it's that little nudge letting them know, I know it's going to be hard, but let's work on this together, doing it in little pieces or at the speed that they're willing to go, and then keeping it focused on the elements of what the Department of Homeland wants to see.
Okay.
And I wanted to tell you guys, we have a tool on how to do the affidavit in a trauma-informed manner, and there's a link there in our materials for you to access that. But the tool helps you identify other behaviors that maybe if the question wasn't there, you probably may not have asked, but because you're following the tool, you have that information. Next slide.
Is it possible for a survivor to apply for a VAWA self-petition if they do not want to leave their abusive partner? What advice do you have to support victims with those services?
You don't have to leave your abuser for any, either VAWA self-petition or U visa. You want a safety plan with them, but there's no requirement to leave them.
Right. And VAWA was designed that way. We knew, many of us that were working on the bill, that immigrant victims were not likely to leave, but at least until they had stable immigration status or work authorization. And so it was explicitly designed, and the confidentiality protections were designed, assuming that victims would apply before they left. So there's lots of work you can do, safety planning and protection orders and custody and all kinds of other things that you can do, helping with benefits access for some victims. And benefits and services that victims qualify without regard to immigration status. So next slide, please. What do survivors need to know about the changes in the filing where USCIS processing locations for filing U visas?
So for Missouri, you guys are still filing with the Vermont Service Center. I always just say, look at it every time right before you send the application, because you don't know if they changed it overnight. So I always get the newest forms from the site.
Sorry, I'm just trying to get the slide in the right place. Go ahead.
Okay, so can you switch the slide, Nora? Thanks. I always check the forms each and every time to check if there's a new one. And I always check where the filing locations are. Both centers are trained on the issues, and that's what I think you need to know.
And one of the new pieces of information we can give you from our most current technical assistance is it's really important to have, even if like some victims will file with an accredited representative or an attorney, other people might be filing with just a victim advocate's assistant. It is super important that there is a safe address for the victim included in the application in addition to the attorney's address. Because we've had some horrible cases where the attorney moved, didn't tell the address, and then they never notified the victim, and then they denied the case and put their in removal proceedings. So it's super important to make sure you work with the client to identify a safe address so that the client, in addition to their representative, gets the notice of anything coming back from the government on their VAWA or U or T visa case.
Next slide. Leslie, can you explain VAWA? I want to see how fast you can do. Explain VAWA confidentiality and who is protected by it.
Next slide, please. So VAWA confidentiality, again, this is something we have lots of webinars and lots of information on this, but the big picture is, as a matter of federal law, the government is not allowed to rely on perpetrator provided information. This is the center column here, to harm victims. And that law applies anytime you have a marriage or, anytime it's a spouse or parent relationship, without regard to when the victim files their immigration case. It also precludes them from relying not only on the perpetrator's information, but his family member, his friend, et cetera, et cetera. It also applies to every victim in the process of applying for a T or U visa. So one of the things we recommend is that if you're working with a victim who's going to be applying for a TRU visa, you or their lawyer or whoever they're working with on the application needs to give them a letter that they carry around with them, and you can figure out how they can carry it safely, that says, I'm in the process of applying for a TRU visa. And then if ICE comes after her, or she gets caught at a traffic stop, she has to show them that piece of paper. And if she shows them that piece of paper, it triggers a process by which they should not be proceeding against her for removal. You also should call us if you have one of these cases, and we can try to make sure that it works right from the DHS side. That is also, these are protections that help us unravel immigration cases filed against victims by the Department of Homeland Security. And this is where the protection from deportation comes from. So as soon as a victim files a case, that case, first of all, is confidential. It'll never be discoverable in a criminal case or in a civil case. The only thing that's discoverable is the certification or the declaration itself in a T or a U visa case, not the file, not everything you file. So there's non-disclosure. And finally, there's protected locations. Victims are protected from immigration enforcement at courthouses. They're protected, and there's we have lots of training materials on that. They're protected at all shelters and transitional housing programs and all kinds of victim service places. So that violating VAWA confidentiality has a disciplinary action or a $5,000 fine against the immigration official that does the violation. So it's very powerful, but this is where the protection from deportation provisions come from and the confidentiality of the application come from. How did I do?
Awesome. That was impressive, Leslie. I just wanted to ask a quick question about that letter.
Sure.
Does it need to include anything besides that they are a victim and what they are applying for?
No.
Okay.
They're a victim in the process of applying. You want actually the minimum information. If in fact, though, there's like a protection order already issued, attach the protection order.
Okay.
Because, the more you're dealing with a law enforcement person who thinks, who's trying to stop, identify undocumented immigrants, and you need to, get them to back off quickly. So whatever evidence you have that might be useful that she could safely carry would also be useful. But the letter is enough to stop them. We've actually had real cases where it works.
Great. And should that be on program letterhead?
Pardon? Yes, absolutely.
Program letterhead. Okay.
Slide, please. So now we're going to talk about the U visa. Next slide, please.
Leslie, what is the current processing time, and can you speak to the cap or any potential for it to be increased?
Okay, so the current processing time for U visas is taking 4 to 6 years and when I say processing time, the way I think about this, and I think the way from a victim safety perspective, we all need to think about it, is it's the point from when she files until she gets work authorization. She gets basically wait list approval, work authorization, and a more formal form of protection from deportation called deferred action that comes with that wait list approval. That's about a 6-year process right now. After that, then there's an 11 or 12-year longer wait to actually get the visa. But she can live and work in the United States safely from the point at which she gets her work authorization. But she can't travel internationally until she gets the visa, and then there's a process. So, and in terms of one of the things that we know, or I know from my conversations and work with DHS, is, the cap is a problem for everybody. It's a problem for them too, because they have to adjudicate cases twice instead of once, which is part of what keeps the backlog up. So at this point, it's not possible to remove the cap administratively. It would take a statutory change. And that's all I can say really about that. I think it's much more helpful to focus on helping law enforcement and prosecutors and judges understand that we shouldn't be paying attention to whether there's a cap or not in terms of helping this victim. That victim should get certification. They should be able to file that case and get it in the system and get the protections of VAWA confidentiality and be on a path to work authorization. And that's the most important thing we could do, where we should be focusing our time and effort. Next slide, please. Rocio, what family members are eligible for U visa relief if a child is a victim of a crime? And what is their application process?
So next slide. If a child is a victim of a crime, then their parents, so long as the parents are not the perpetrators, can also apply, and their siblings under the age of 18. So I shared with you here, if the survivor is 21 and older, then it's their spouse and unmarried children. Then if under, that's what I just answered right now, about 21 years old. As Leslie said, step parents count as if parent, just pretend it's parent. So step parent also is eligible as long as they're not the perpetrator. The family members have to be also do a waiver and be admissible. And in some cases, the child is a U.S. citizen and the parent is the one that's undocumented. I've seen that sometimes. Often in when it's a sexual assault case, and in those cases, the parent can be the principal applicant.
Right. The parent can qualify even though they weren't abused themselves, whether or not they were also abused themselves. And I just wanted to tell you, Corinne, just to make a note, we have a brand new tool on U's and T's, a little chart, a cheat sheet that shows you all the family members who can come into each application. So we'll share that with you after the training. So Rocio, survivors often do not wish to involve law enforcement in their case. Are they eligible for the U visa if they don't want to report the abuse to the police? And if so, how?
So next slide, there is a component of helpfulness to the U visa. The requirements are that they're a victim of the qualifying crimes. So the crimes that Leslie showed earlier, in our work, sexual assault, domestic violence, stalking, and the list goes on, and that the crime happened here in the US, that they were helpful, are helpful, or are willing to be helpful in the investigation of that crime. So it doesn't necessarily need to be the police, but each U visa has to have a certification that signed by a authorized law enforcement agencies. And it's not just law enforcement, it includes federal law enforcement, prosecutors, judges, magistrates. The judge could be in a civil case, in a divorce case, a criminal case. It could be the Department of Labor. It can be the EEOC. It could be Child Protective Services or Adult Protective Services. So maybe in those cases, there wasn't police involved, but the CPS was involved and they can certify the case. So just to rephrase that a little more neatly, each U visa case has to have a certification, and that has to be signed by somebody with authority, an agency that has investigation authority.
Or detection, or doesn't have to be just investigation, detection of the authority to investigate, to detect, investigate, prosecute, convict, or sentence, or any of those.
And that's what makes it important. They didn't want us to be like police, that's it. And that's why there's the range of certifiers that we changed here. And so I know there's a question later on what to do and strategize working with the police, but that's why there's other options for you. So it doesn't have to be police, and it could be also the courts.
Right.
Next slide.
And we do have a tool on range of certifiers. Maybe Corinne, you can make a note and we'll send you that too. Because police, there's another thing with police, if I may. It can be, depends what, many jurisdictions, and I know this is true in Missouri because you have so many rural areas, right? So you might have a local police department, you might have a sheriff, and you have state police. And any of those can certify on a state level. And in many places, like most of the places we run into in the country where the police won't certify, we can find that the sheriffs will. And, sometimes it varies. So you really can get creative about who, all the different potential certifiers.
Right. And so that brings it right really nicely into this next question, because they were so well put there. But what are some strategies? What do you do when you're working with law enforcement and they refuse to sign that certification?
So first of all, if how many of you are working locally in coordinated community response efforts around either domestic violence, sexual assault, or stalking in your communities where there's somebody from law enforcement at the table? I don't see any hands. Can that be Nora?
Probably not.
I got one.
Okay.
Donna?
Okay. So one of the things that we request you do, that we think you should do, is bring the issue of certification to the table in those coordinated community response efforts. Because then you may, if you have those discussions, you might trigger, if you have a law enforcement agency that says, is willing to say, with the judge sitting there who's also on the team, we don't do this. Sometimes bringing them up in that environment and getting them, working through those relationships to get them to certify can be helpful, or to get them to be interested in having training to learn about certification, or to get them to be willing to talk to another law enforcement officer who's an expert on certification. So we can't, let's say, if Nora, you called me up and said, go have one of your police officers talk to this guy, he won't do anything. We can't sick our police officers on another police officer unless they're willing to talk to them. But we understood when we wrote the statute that we created all these multiple certifiers because we knew there would be, in fact, there was a case, and I won't tell you the story now, but in the middle of the negotiations, there was a case just like this, where, people couldn't get protection orders because in that community, the sheriff and the judge were both perpetrators. And so it was like, what do you do? And so we had that conversation, and that's why we have so many certifiers, and your judges have been trained on certification. And, all you have to do is go in and get a protection order, and based on the protection order, you can get a cert, or you raise the domestic violence or child abuse in the custody case or the divorce case, and you can get a cert. So there are there are other ways around it, and really do encourage you to think creatively. And on the one hand, build the relationships that can foster certification in the future. And I know we're coming up on language access. Our research has shown that the relationships that build better language access to law enforcement services also build a greater willingness to sign certifications. So building those relationships with law enforcement is always a good thing. We do provide technical assistance on that. Next slide, please. And great. So fine. Yeah.
Oh, sorry. Do you want to go back?
No. I don't think I missed anything. That's good. Oh, yes. Go back one, please. So just so you know, we have a support system that we've built nationally for law enforcement and prosecutors. So if you are working with law enforcement and prosecutors who are interested in learning more about how they can serve immigrant victims, encouraging them to join this roundtable could have the long-term effect of encouraging them ultimately to certify, because this is a group of law enforcement and officers from across the country that are using certification successfully in their communities. And it's a really good way. So maybe you can build towards the future by getting more of your law enforcement officers interested in joining this group. Next slide, please.
Leslie, what other forms of relief are available if a survivor is not eligible for U visa or VAWA self-petition?
So the major one that I would say, so first of all, the number of survivors that you're going to work with who are not victims of domestic violence, sexual assault, stalking, child abuse, elder abuse, anybody who's in any of those categories will be eligible for a VAWA self-petition or a U visa. The group that another option for that group is what I mentioned earlier called special immigrant juvenile status, which is a form of immigration relief available to any child who's anybody who's under the age of, what's the age of majority in Missouri? Is it 21 or 18? Do you know? Anybody? I could look it up. Corinne will look it up and send it to them.
Thanks.
But whatever the age of majority is, any child under the age of majority in Missouri who was ever abused anywhere in the world by a parent, abused, abandoned, or neglected, qualifies for special immigrant juvenile status. And so that's another form of relief that I find that is underused for children of, let's say, U visa victims who are in that long line. The kids can be included in the case, but if the kids can file for special immigrant juvenile status, they'll get their status before mom gets her U visa. Asylum is a difficult form of relief that has always been difficult to access, and really helps people where they were abused as victims abroad. It's not as readily available today as it has been, and so it's highly unlikely. I mean, hopefully most of the victims, because you're working in victim services, that you see will qualify for one of the other forms of relief. And as to DACA, my big pitch on DACA has always been, if you are working with a client and her child has DACA and has already applied or is eligible for DACA, the first thing you want to do is screen that child for VAWA, T, U, SIJ, and those kinds of things, because DACA doesn't have a path to permanent status, and these other forms of victimization-based relief do. So that's the other issue, is to really, I would be surprised that you in your work will run into survivors who don't qualify for either the T visa, the U visa, SIJ, or VAWA. Rocio, is that your experience too?
Right, same thing. With DACA, the people that currently have DACA can reapply for it, but right now, as if we know, they can't, not new people can be applied to DACA.
Okay.
And the age of majority is 18 in the state of Missouri.
Okay, so by 18. Next slide, please. Actually, 2 slides. So we're going to switch to public benefits.
So what should we service providers be telling immigrants about the public charge rule?
So it's not what they should be telling. So if you're working with immigrant survivors, so we have done a brand new tool on this for NNEDV that we can share with you on public charge. We're actually in the process of finalizing some infographics and this and that and the other. But the long and short of it is VAWA self-petitioners, U visas, T visas are all exempt from public charge. SIJ children exempt from public charge. DACA children exempt from public charge. Lawful permanent residents exempt from public charge. There are a lot of groups, again, if you are working with victims, there's very, very limited times when a victim would have a public charge problem. And again, we have a brand new tool where you can we have a flow chart and an infographic, and then this long document with all the footnotes. So we'll get you that material, but generally speaking, from a crime victim perspective, public charge is not an issue.
Yeah, I'm sharing with the group that it's very important if they're eligible for the service, or there's a lot of misinformation about public charge, and a lot of survivors are scared to access anything, but it's important that we do connect them with those resources, especially if they're eligible. We're going to share with you our map, but it's sometimes going to take a little time to explain, but look, because you're a victim, because there's nothing wrong with getting the support, because this is what's going to lift them up of this situation.
Right. And what's interesting is in the immigrant rights community, people are so afraid about public charge, and there's so much talking about it, it chills victims who are eligible. And so our role is to kind of get them to the services they're eligible for and make sure that they know and understand that public charge isn't going to be a problem for them. So
how can they find out about what they're eligible for based on their immigration status?
Okay, next slide, please. Next slide, please. Okay, great. So there we go. So we have a public benefits map. And what's great about this map is it's interactive. So on the left-hand side, you can see cash benefits, child health insurance, driver's license, childcare. There's a whole list. It's got housing, shelter, FEMA, driver's licenses, post-secondary educational grants and loans, all of the things, all of the kind of benefits. What is not here yet is unemployment insurance. We are working on that. But the law as to unemployment insurance and immigrant victims, we have in the COVID-19 publication we shared earlier. But the way this works is we were trying to create an easy tool so that if you're working with a victim and you know she's applying for a U visa, or you know she's a refugee, you can click on Missouri, you can click on TANF, and you can click on Missouri, and it will tell you in Missouri which forms of immigration relief which victims, based on their immigration relief, of what form of immigration relief they have or have applied for, whether they're eligible or not. So you don't have to spend any more time on TANF if it says not eligible. If it says eligible, or if it says eligible with conditions, at the bottom of the page, there's a link. You click on that link and you get a giant chart where you can see the details of why this victim is eligible for TANF because she's a refugee, for example. And then it has footnotes that if you want to go help her apply, you click on the footnote and it tells you what documents you can take with you. So you can actually download the law and take it with you. So show the benefits worker that she qualifies. And so the idea here is you can quickly see who qualifies or not, you can advise people, and you can do it for every kind of benefit that we've been able to think of so far. And it connects to materials and resources and has links to publications and everything. So it's a really good tool for you. Next slide, please.
In civil proceedings, who is required to provide the interpreter? Tell us first about the court and then tell us about attorneys.
Okay, can you, next slide? So we're going to go through slides on this one, Nora. So on this one, basically, under the Civil Rights Act, Title 6 of the Civil Rights Act of 1964, anybody who is a government agency or receives government funding must provide meaningful access to persons who to programs and benefits to persons with limited English proficiency. And so that would include the deaf and hard of hearing. It would include Spanish speakers. It would include people who speak Arabic, whatever language it is that they need. Next slide, please. And specifically to courts, courts are supposed to be providing qualified interpreters to all kinds of cases, civil, criminal, protection order, in the courtrooms, in the clerk's office where people are filing papers, you're supposed to be able to get an interpreter if you have to ask a question at the information booth at the court. All of those, and that they're supposed to be provided without fees to the victims. Next slide, please. And that it also includes things like if pro se clinics, or if they're ordered to do alternative dispute resolution, or if somebody's ordered into treatment, or to take let's say they're doing a DNA test for child support. The interpretive services are supposed to be provided by courts for all of those activities. And it's my understanding we can put you, I think, Nora, we may have already put you guys in touch with the people in the Office of,
Oh, yeah.
the
Office
people
of
in
State Court Administrators, the Access to Justice Program.
Exactly, is responsible for making this happening in court setting. So next slide, please. So Rocio, do you have recommendations for using interpreters while practicing social distancing?
I do. I wanted to say with the language access that I shared there on the chat that it's the same law that says that we in our programs, we have to provide language access too. And if we don't, we can run the risk of losing our funding. So just wanted to make the connection that the same obligations the courts and law enforcement are the same ones that we do when people reach out to most of our programs. For using interpreters while social distancing, I would say,
Next slide, please.
Next slide, please. That, allow for time, because it's going to be the same constraints that we had before, but except it's going to be a little bit harder because now we're separated. But just make sure you're giving yourself that time, and do it in little pieces if you need to. I wanted to share with you our partners at Asian Pacific Gender-Based Violence Institute. I scrambled up their name, Asian Pacific Institute on Gender-Based Violence. They're a TA provider too, and they're who we go to when we wanted to explore anything on language access or have share materials. We are doing a presentation, invited them to talk with our family law attorneys this month, and they shared a wealth of resources, really neat stuff. And that next slide, this is one example of them, but I'm going to share them with Nora after. There's 6 handouts, and some of them are even in Spanish, so you can give them to survivors ahead of time so they can know what to expect. But that's what the courts are doing now. That's how attorneys are doing. That's how we're doing everything. So we all need to brush up on our remote interpreter usage. Next slide.
So my advice to, in terms of victim advocate attorney collaborations, I really think, so one of the models that we're encouraging people to do is that attorneys and advocates work together. And that we have some samples we could share with you of, there's ways to do attorney-client, basically the agreements that a victim would sign with her attorney that include the advocate, so that attorney-client privilege can actually extend to the advocate, and that it can get set up in advance if you're working with an attorney, that, you know, how you can safely share information. What I will tell you, and this is one of the things I worked on very early with victim advocates, is with immigrant victims, that sharing of information is really important, because the immigration case can't go forward until if the victim advocate and the attorney can't collaborate. So we're happy to provide technical assistance and work with the coalition and others of you to think about how to build and structure those relationships so that information can flow from the attorney and to the advocate and vice versa, so that the victim's immigration cases can get filed. And if they don't get filed, then there's more harm to the victim happening than any confidentiality breach that there could be potentially. You just have to really think about it in line. Close to the end. Next slide. No. Okay. Had to do with the judges in Missouri. And all I really want to say here is my biggest tip to all of you is we have trained them on special immigrant juvenile status and findings. We have trained the judge on VAWA confidentiality and discovery. We have trained the judges to sign T and U visa certifications. Their biggest complaint is nobody's asking them. So they've been trained. And so it's really important that if you're working with victims going to court, that you're thinking about asking judges for these things. And if you have lawyers that say, I can't do that, send them to me and Rocio, and we'll straighten them out. So part of it is you need to ask more, I think, and there's a team of judges who are there ready to help in Missouri. Next slide, please. Rocio, what is the best way for service providers to stay informed about the policies and kind of emerging needs in the field regarding immigrant survivors?
Yeah, next slide. The way I do is, well, from the TA and from hearing what's going on the ground, but aside from that, there's a group called the Alliance for Immigrant Survivors. I'll share the link with you there, and Corinne will put it up for us. But they have the action alert, the policy stuff, the stuff we hardly aren't directly involved, but it's important and it impacts our community. And there it's run by Assista, Tahiri, Casa Esperanza, and API. So they have action alerts. That's how I get a lot of the information.
And the other piece I wanted to say is we will share with you when we send the materials follow-up. We have a newsletter, and anytime there is a new, anytime something becomes law, there is a new policy that gets issued by DHS. There's a win in a court case that affects cases, or, the law changes in some way, or there's a new publication that's useful. We distribute it through our newsletter to anybody in our network. So if you sign up for our network, you are getting Rocio's eyes and ears on what all these other groups are doing and sharing new information with you as it becomes available. So that's another way to do it. Next slide, please. And I think then we're concluding because I know we're coming close. So I guess my answer to this question is, I'm going to go back to kind of what I said in the beginning. I think the most important thing, what I'm most hopeful for, is that people are fully using everything the law currently provides to help survivors. And I think our time is best spent focusing on what is in the law today and using that to help survivors and support survivors. And I'm talking about all the benefits they're eligible for, all the services they're eligible for, getting protection orders, getting them, supporting them and convincing them to apply for immigration relief and that it's safe to do so. That to me is much more important than focusing on what might happen in the future, because we don't know. And I'll tell you, when I started doing this work, everything that we've been able to accomplish, people told us was impossible. And so I think all's possible at some point in the future, but possible isn't what helps your client today. Possible or not possible could drive you crazy and deflate you so you can't help your client today. So it's important to really, really look at what is possible and work with that, because there's so much more we could be doing for our immigrant and refugee clients than we're doing now.
I love that. That's great, Leslie.
And then I think at the end, we just have some resources to share with you. This is where you call for this is how you reach us. And we will again send you, Nora, I assume you'll share emails for everybody, and then we'll have Corin send all the material to you so that you have them. You'll have the number for how to call us if you're working on a case and you have a question. And I think it was Carla's question in the beginning was a great example of the kinds of questions we take. So I think I will conclude that. And I thank you guys for your time and attention and your extra 5 minutes, Rocio.
I wanted to thank everybody for your work you do, and I hope you feel comfortable. Maybe you've seen us a few times now that you feel comfortable enough to reach out, but I hope our relationship is stronger because we met here, and that your work going forward it feels supported. Nora?
Well, I just want to thank you so much, Leslie and Rocio. That was such a wonderful whirlwind of information that was very, very helpful. So thank you so much. And thank you all of you who are on the call for sticking around. It was wonderful to see you. I will be sending out information about the next URSR meeting that we have in the spring. But until then, you can always give us a call at the Coalition. NUAP is here to support you. And I will stick around on the call if anybody has any comments or anything they want to say. But Rocio, I know you've got a flight to catch, and we just really appreciate you, NUAP, for being here. Thank you so much. That was great.
Bye.
So thank you all, everyone.
Thank you, Nora, and thank you, Nancy.
Thank you, Leslie. That was wonderful information. I really appreciate it.
My pleasure. Thanks for inviting us.
Thank you. It's nice to see you again.
Likewise. I wish it was in person, but
Someday soon, hopefully.
Exactly. Okay. Take care, guys.
Bye, Leslie.
Bye.
Nora, this is Deb.
Hey, Deb.
Hi.
I have a couple of questions. First, did you able to record it?
Yes, actually, thanks for that reminder. I'll stop recording.